Next up is This Week in Law, and we've got a real great show for you. We're going to introduce you to Carmel, the new puppy. Here she is. Hallie Suit Tucker is with us, author of Founders Less Than Three. We've got Jonathan Ezor with us from Touro Law. We're going to talk author issues, digital publishing, privacy, all sorts of good stuff. Evan Brown, of course, is here too. Don't miss it next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown. Episode 232, recorded October 18th, 2013. The Carmel Commission. Hi, folks. It's Denise Howell, and you're joining us for This Week in Law. Once again, we are so glad you're here with us. Here with us, as usual, is my co-host, Evan Brown. Hello, Evan.
Denise, it's great to see you. Happy Friday. This is going to be a really fun time. Looking forward to our conversation.
It is going to be a really fun time. We've been having all kinds of fun before the show even started, so we're just going to carry it on here. One of my oldest online friends is with us today, a woman who I respect, admire, and who always gives me a huge kick whenever I get to talk to her, and that is Hallie Suit Tucker. Hello, Hallie.
Oh, shucks. You can't start like that. Thank you. I can't wait to talk about self-publishing and all the legal parts of publishing that I've been running into this year as I wrote and self-published a book.
Yes, Founders Less Than Three. Hallie had a successful Kickstarter campaign, so kudos on that.
Thank you.
Holed up for a bit in Boston and hunkered down and wrote her book. So living the dream, Hallie. That's great.
It's funny how many people want to know all about crowdfunding, and I end up speaking almost more about that lately than even my book, which is fine. It's great, and it was a very interesting experiment. I personally don't think Kickstarter is about crowdfunding. I think it's about branding and a platform to create interest in whatever project you're doing a year ahead of when you are done with it. It's interesting to me that way.
Mm-hmm. Also joining us from Touro Law in New York is Jonathan Ezor. Am I saying your name right, Jonathan? I'm sorry. I should have asked you before the show.
You got it correct. It is Ezor. Ezor. And I'm happy to be part of the conversation today.
It's great to have you. Jonathan is the director of the Center for Innovation in Business, Law, and Technology at Touro, and also a professor there, and teaches on subjects that are very common fodder for our show. So we're thrilled you could join us.
As I said, I'm very happy to be here. Thank you.
All right. Let's get into some publishing-related stuff. Of course, like a lot of things in technology, when you mix a traditional medium with technology and crowdfunding and the ability to go directly to an audience, all sorts of interesting and not necessarily expected things happen. Including recently this week, as Hallie clued us in before the show, a whole brouhaha where Amazon and W.H. White and Barnes & Noble have had to pull a bunch of titles. W.H. White actually shut down its whole site, didn't they, Hallie?
Yep, that's right. That's right.
Which is a big deal because what was happening was a bunch of books involving, self-published books involving pornography and incest and abuse were showing up in search results on these various sites, counter to the site's terms of service. They were flagged by somebody out there, did some kind of sleuthing and expose and figured out that this was happening. Now they're trying to mop up and figure out, okay, not only how can we solve this problem, but how can we make sure that in this crazy world of self-publishing, that our terms of service are actually being complied with. Hallie, can you tell us a bit more?
Sure. What's interesting to me is it suggests we have just so much going on in self-publishing, week to week, day to day. Everything's changing, and everybo's trying to put on their safety belt, their seatbelt for a wild ride. So this story started in the UK. Kernel magazine, it's KERNAL, wrote an expose, reasonably a good subject, to talk about the fact that there were books, self-published ebooks, being put up on sites. People would use different tags. For instance, they wouldn't just say they were erotic or they were whatever, adult. They were putting them up under places like children's literature. But here's some of the literature that they exposed. Things like Daddy's Invisible Condom and Don't Daddy, some horrible titles. And then some were retitled so they could be hidden even more. And so what they did was write an article that was very, very explosive about ebooks that had featured rape, pedophiles and sexual abuse and all sorts of things. And as a result, as you mentioned, there's so many books, and the surge in ebook publishing is so vast that some reactions, like W.H. Smith, they shut down their entire site. So before they could get in any trouble, I suppose, or sort through them. And a great writer on this subject is Laura Hazard Owen over at GigaOM. And as she said, how are they going to go through this many books? Just for a piece of data on books, last year, 300,000 odd hardcover books were published and 391,000 self-published ebooks were published. So it's just an enormous amount. Together with, there's been a 59% increase between 2011 and 2012 of ebooks published. They have tricky ways to hide them in these titles. And we're in, as I told you, I think we're in this post 50 Shades of Grey publishing realm. So how exactly, no one even believed that book would do as well as it did. And it has some pretty saucy content. So yeah. I think they've got their work cut out for them. What do you think, Denise?
I do. I mean, it's a similar project and problem to what search engines in general face in trying to present things in a family-friendly kind of way. W.H. Smith, of course, not W.H. White. I must have Breaking Bad on the brain in the aftermath of, Walter White. So the publisher W.H. Smith is who had to shut down their site. And, for all of these online retailers, it must just be a huge challenge because on the one hand, they're so excited that they get to share in all of this self-publishing revenue. But on the other hand, they have to carefully police what's going on their site. Jonathan, I'm sure we're just in early days of this problem and how it will be managed. Do you think that the solution will be more legal or technological or some combination thereof?
I suspect that it's probably more a technological solution, allowing consumers to filter, maybe be creating some tags for the individual pages that can better inform the search engines. To suggest that a bookstore which wants to be all things to all people is going to censor some of those things, that's a business decision. I don't see that this is a legal issue in terms of enforcement, more a question of self-policing and making sure that whatever the legal regime in whichever country you're in, there's no exposure for self-policing. I know you had the discussion on 47 USC 230 a few weeks ago, and talking about how our law was revised to incentivize self-policing.
Right. And certainly in the United States, the sites themselves might take some comfort in the fact that Section 230 of the Communications Decency Act exists, and to the extent there's anything unlawful about making these titles available It would depend on how the site operates, wouldn't it, Evan? To the extent they're vetting anything, then their ability to take cover under Section 230 might be impinged. But to the extent they're just acting as a platform, like any other online platform, such as YouTube or any other place where you can publish things that you've created yourself, then 230 might give them some cover. But I'm thinking more from the sites just don't want this kind of activity going on, and how they can police it, how they can actually prevent what Hallie's talking about, people trying to take cover behind innocent sounding categories and tags and still making their works available on these big platforms. Where do you think this will go, Evan?
Well, first of all, 230 protects good faith activity on the part of the platform in removing content that it finds lascivious or lewd or offensive,
right,
regardless of the First Amendment issues here. So I'm looking at this at a very basic and fundamental level and seeing that this medium certainly is experiencing some tremendous growing pains, and the strain that we're seeing in those growing pains focuses particularly on the roles that traditionally have been played by the publisher and the bookstore. So what we see here is with the innovations that are going on that have happened that allow more people to self-publish, naturally we see an influx of self-publishing. Hallie's already cited the statistic of well over 1,000 books a day are self-published.
Right.
At least that was the data from the last year. We can only expect that number to be probably going up exponentially. So what we see here is this strain on these roles that the publisher and the bookstore have traditionally played. And those roles have been as gatekeepers for good content. A bookstore is not going to carry a book that doesn't meet a certain standard of quality. Most of the words have to be well spelled and the pages formatted well, and that's the same role that the publisher plays in deciding which books are published and which are not. So perhaps what needs to happen here is a real fundamental shift and a new space altogether to be created for self-published works. That's fine to think about for a little bit, but then we also recognize, well, wait, isn't that what the World Wide Web is to begin with? A place where people can go self-publish things. So I'm not so sure how far we need to take this. And again, I'm looking at this at a very simplistic, fundamental level. I don't consider myself a publishing industry insider or having any special knowledge. I do represent some publishers and some authors, but I'm looking at this just at the very general level here. Are we really trying to mash two ideas together, the totally free and open publishing environment that we enjoy on the World Wide Web with these into these roles that have traditionally played the role of gatekeeper, the bookstores and the publisher? And is that why we're seeing these growing pains and we just need to rethink it at a fundamental level? That's what I'm starting to consider.
Jonathan, how do you think, from a business standpoint, sites like Amazon and others who make self-published titles available and have that as becoming more and more a part of their business model, how do you think they're going to balance the outcry on the one hand if they're having incest and abuse and pornography available, in titles on their site, or the cry about censorship if they're keeping those things from being available? Right. I'm reading a book right now that features an Émile Zola play that at the time was quite scandalous, and people wanted to keep it off the stage, and we would look at it today and it might well put us to sleep. So people's mores change.
I suspect that each of these individual volumes, the amount, the percentage of Amazon sales that one of these books represents is probably one of those numbers that would require a whole lot of spaces to the right of the decimal point. That Amazon probably is best off pulling these on an individual basis when it gets complaints. But as part of this discussion, though, it occurred to me that there is an additional possible challenge or problem that Amazon and other mainstream ebook publishers might face in encouraging self-publishing. And that is that it's not just about the words and the titles. Ebooks today can embed images. They can also embed hyperlinks. And if I were someone who wanted to use mainstream channels to either directly distribute or point people towards non-mainstream content, perhaps even illegal content, the idea of putting out a very inexpensive ebook through a mainstream publisher that embeds links to some nasty stuff, I wonder whether the tools would prevent that. People are always going to be more creative than automated business processes can stop or can control. It was true in copying. It was true in spam. So that I think Amazon is probably best from a business perspective, taking the approach of here are our guidelines, here's what we want, and here is a very easy and effective way for customers to let us know if we've been fooled, and we will take action immediately.
Denise, can I add another thing on this? This has some levels, and the title of the article, the original article, give you some idea of what also is going on over there. How Amazon cashes in on Kindle filth is what it was called. The subtext says how tax-dodging online retailer Amazon cashes in on depraved amateur literature that glorifies rape, incest, and child abuse. So we just recently had friends over from Germany, and Amazon is not beloved in the EU, in the UK, and there's big tax considerations. They feel like they are skirting, fair taxation, and all the money's going back to Amazon and not staying in those countries. And then our friends in Germany were telling us about a factory they're building, Amazon is building in Berlin, and that they are going against the union rules for paying workers and breaks for workers and how many hours people can work. So Amazon is, I think, much loved in the US and much not loved in Europe right now. There's a lot changing around. They're having a lot of trouble getting in there. And just the fact that I think we all in the U.S. are using ebooks so much more than you see there. Have you heard about that?
No, I hadn't heard that they're so much less popular in the UK and elsewhere in the EU for the reasons that you mentioned. I have, obviously we've been following along as various states in the U.S. have done battle with Amazon over the taxation issue. And I'm sure that, wherever they do business, they're going to face similar kinds of concerns. How do you feel about them, Hallie, as an author, as a platform for you?
Well, for American authors, there's some simple math that makes all the sense in the world to just bow down before them and love them, because traditional publishing, the royalty scenario would be that you would get 30% and as the writer, and the traditional publisher would keep 70%. That's the opposite of most of the pricing on Amazon. It depends on the price you set for your book, but the majority of the deal is that Amazon gives you 70% of the revenue that's made on the book, and they keep 30%. Very different also is that a traditional publisher, it's almost like the old movie business where the movie stars thought, wait a minute, we finally get a percentage after 2 years and we get some small piece of, not the gross, the net. The old publishing method, you might not see royalties for a year and a half or longer. You have your money for your book, the 70% of whatever you earned is directly deposited into your accounts 90 days after you sell it. So Amazon sets up your bank with you. I mean, they're amazing in that way. And we're in an environment in publishing where the things publishing used to offer, like helping you promote the book or helping you go on book tours or all of this, is essentially disappeared. So you're getting more money from Amazon. They have enormous reach. They have gotten rid of any issues of shipping and warehousing. So all the physical part of it is gone. And they do, of course, not only Kindle to do the ebook, but they do CreateSpace, a company they bought that does your paper book. And I'll show you my book. They did a beautiful job. And it's, it's got a nice spine. It's got nice photo on the back and all this. So it's hard to distinguish from a conventional paperback, traditional published book. So there are many fans. Most writers are big fans of Amazon in the US because it's amazing what they can do for you.
So you used CreateSpace to do the physical copy of your book.
I did.
And that was a good experience for you?
It's very good. The thing that's kind of frightening is you send, you don't even put any money up front. When you do an ebook, you send your cover photograph, which is what I had for Founders Less Than 3. And this is a postcard of it, but you send a Word manuscript, your whole manuscript just in Word, like Microsoft Word, and you write the little advertising spiel that goes on the site. Someone asked me the other day when I was talking about this, how much money do you give them? You give them no money. There's no money to it. You send it to them. It's up within 24 hours or less for sale. And that's the ebook. And the paper book takes about a day. You send in your PDF that's been paginated properly for a paperback book, and they publish and start selling within, I know Guy Kawasaki often quotes when he did his book about author, publisher, entrepreneur, which is a totally great book, Ape. They sent the manuscript to CreateSpace that happened to be on Christmas, December 25, and they got readable copies back to proof 2 days later. It's incredibly fast. Which means you also can then write 3 more books in the 3 years you would usually wait on a regular publisher to do whatever they do.
My dad is having a great experience with them as well right now, where he had a manuscript laying around for quite some time that he needed to have edited and polished and put out, but he just, he has kind of been sitting on it. So he's using the part of CreateSpace that you do pay for, where you have a professional editor come in, and and he's loving it. He's thinking they do a really good job. But I'm wondering, I, have not closely gone through his agreement with them as far as what rights he is signing over to them by publishing on their platform. Hallie, you may have paid closer attention to that than my father has at this point, since he's not quite ready to pull the trigger and publish his book yet. Do you feel comfortable that you will have all the rights that you want as an author, the rights to distribute and digitally publish as you see fit?
I think the list of things they grant and the rights they give to you and you retain as the author are really generous and compelling. And you need to read whatever contract they give you next to the awful contracts that you read about. As I had mentioned to you, the romance writers are having a big class action suit about all of their rights taken. The rights to have your back list of books. What really makes people wealthy on Amazon e-publishing is when you can put a lot of books up. It's almost become like, people buying in a store, point of purchase, like the prices are $1 and $2 and $3.99 for books. So people do a lot of impulse buying on their Kindle. They're laying in bed late at night. They read a book, and it's so easy to buy other books. So if you have a list of back copy books that you can, like your dad, quickly just get up online, that really helps you. So I think people are pretty happy with Amazon's contracts. Now, of course, it's a giant gorilla. So someday, what happens when Amazon says, oh, it's not 70-30 anymore, we just changed it, now you get, it's 50-50. They can do that. So, but you would compare that to the fact that it's very hard to even get in to traditional publishing, to get an agent, to proceed in the old ways. So many of the traditional publishers, not their fault, but they're just super understaffed. They don't have people. I mean, when I met Guy and talked him into self-publishing because he was complaining so much about traditional publishers. Guy Kawasaki is kind of well known. They weren't giving him any promotion for his books. They weren't helping him. They have a limited budget, and they just give a little bit to a very well-known set of authors. So that's why he made the switch. And he's not going back anytime soon to traditional publishing. So.
Yeah. Well, let's talk about the Harlequin dispute that you mentioned, because that's really fascinating and a good example of how authors are using the fact that there's competition out there to come after people that, I don't know if you would consider Harlequin a traditional publisher or not. I think I would, because they've been around for a long time. And so what's gone on here, apparently, per the writing around this, there's a website called harlequinlawsuit.com that aggregates the pleadings and things about this class action suit by the authors against Harlequin. And the gist appears to be that the publisher is allowed to sublicense to things like book clubs. And the book club can pay a small fee for that sublicense and then doesn't owe fees after that to the author. So it's a way of getting broader distribution for the book, but it doesn't pay as well to the author. So what Harlequin is being accused of doing here is basically setting up a shell sub-licensee that is actually part of its own corporate organization, and using this term of the contract to, say, oh, well, we're actually sub-licensing these out, and that's going to be good for you in the long run, but you're going to get less money. And I think basically, I haven't read the complaint, but the claim that jumps to mind when I read this is fraud in the inducement, that Harlequin, has sort of baited and switched them and told them one thing would be going on, but is found another, maybe technically legal way to keep more of the money and take more of it away from the authors. Do you think that that's, again, I don't know if you've read the complaint yet, Evan, but that strikes me the tenor of this lawsuit?
Yeah, that's what I gathered. And, I mean, it's Harlequin. It's a little bit, isn't it a little bit, well, it's very idealized, right? These are the ones that have the real, when I conjure up an image of the Harlequin romance novels, the very idealized romantic scenes. So, what kind of scruples are they coming at it with? But
these are bodice rippers.
Yes, I'm paging through the complaint right now, trying to see what it is they're trying to assert here. Breach of contract.
You're not paging through a Harlequin romance novel instead. It's not.
May I add something? I spent about 2 years ago, I was in the Techstars Accelerator program for new startups, and I was with a startup that was trying to figure out how to help. It's called discovery in ebooks. You write books, and if nobody finds out about you, it never goes anywhere. And I went to a number of conferences to hear everything that's like late breaking news with ebooks and who's really pushing the edge. And I'm going to tell you, these romance chicks, man, they were incredible. Okay, they are doing some of the most inventive things, and they're not to be made fun of. And the whole, it looks a little like, Legally Blonde. Okay. You go to a conference and there's more pink, per square inch than you can believe. But these girls, they are doing lawsuits. They're fighting with these publishers. They're doing rather amazing things, and they're creating these amazing ways to sell books. So my pillbox hat should be off to these ladies. They're doing incredible things. They ended up being kind of the biggest innovators, because they have been I think they've really been taken advantage of. Many of their backlist books they get you in these contracts that's like slavery, that you can't get out. You can't get the rights back to your books. You can't publish them, yourself. It's pretty serious stuff. So these girls are really going to change e-publishing. They're not to be messed with.
Well, it should come as no surprise because they're so amped up, right? I mean, with all this content, when you go to the bookstore, you see so much. So you can imagine that there's a lot of energy being poured into this. It seems like it wouldn't be much surprise that there's a lot going on there.
Yeah.
Right.
This is pending in your neck of the woods, Jonathan. It's in the Southern District of New York, and the claims being asserted are various flavors of breach of contract and unjust enrichment. So no fraud in the inducement being asserted here unless they're sort of couching one of the contract claims that way. Do you think that this kind of a bait and switch, it seems kind of too cute by half, don't you think?
I haven't read the complaint. That's sort of the lawyer answer. But so I'm not sure about this particular situation. Anytime you're dealing with a big brand, there's the two sides. One is people want to work with it. Right? They don't want to just self-publish. They'd much rather have a Harlequin romance than a romance novel. You get, the benefit of the brand. But at the same time, you get that sort of bully feeling that might appeal to a jury if it's a jury trial, et cetera. I was struck with sort of the idea of the Harlequin authors, the romance authors being the innovators.
They
Not
are.
only, but it's no surprise. Think about who is credited with most of the innovations in streaming media and e-commerce security. It's the porn industry.
Warren,
Right.
And much the same reason, in that there's a lot of money to be made from a lot of customers who are looking to spend large quantities of small amounts.
Mm-hmm.
And you have creative people who are both trying to leverage and fight the big industries. So it's an irony. It's not particularly surprising that you're seeing the innovation, the technological innovation, from those authors who have probably been fighting to be mainstream and recognized as mainstream in the same way that adult content providers have been fighting to be part of the mainstream of video and movies for a long time.
So that lawsuit is ongoing. It's a class action against Harlequin by the authors trying to address this strange way that they have set up their sub-licensing and see if they can show that that's counter to what the authors actually agreed to. We're going to go ahead and drop our first MCLE passphrase into the show. That is romantic innovators today. If you're listening to the show for professional credit in the legal or another profession and you need to demonstrate you've actually listened through the whole show, this is one way that you can assure people that you have. We put two phrases in each show. So the first one's romantic innovators. We'll drop another one in at some point. And if you need more information about getting professional credit for listening or watching the show, head on over to the Twit Wiki at wiki.twit.tv. On our show page there, there will be lots of information for you. Also, Jonathan, I just wanted to mention a while back on the show, we had Tim Street, and he too is an author. And you were mentioning just how flexible ebooks are, that they're not just text, that they can have links and images. Tim wrote a really interesting book called Vids that is sort of a murder mystery. I don't know if it's a murder mystery. I haven't read all the way through it, but someone has gone missing, and you have to piece together from various video clips and other things what exactly happened here. So his book Vids is replete not just with photos, but also with videos. So that, and it's actually, let's see, it's available through iBooks. So it's using their really interesting formatting that you can do. So it, just another wrinkle to what people can put in their books and the kind of content, how it's difficult to police the content that's in a digital book these days.
Right. And how do you define a book? When you just put that screen up, I looked very carefully to see if it was through iBooks or the or an app.
Right.
Because you have games that are being reviewed on their plots and their dialogue.
Right.
And many of them have text, a combination of text and video. The definition of a book now is a very fluid one.
Mm-hmm.
And I can certainly see that, but for the fact that, at least as I can see on my screen, that is listed in the category of erotica, that might be why Tim has turned it into a book through iBooks as opposed to a game, because there may be different guidelines for Apple, even if it's being read on the same device, and ultimately going through the same system.
Right. Well, we've had porn, we've had incest, we've had romance. Can we have some Kardashians too? I mean, I don't see why we wouldn't at that point.
All the same.
Exactly.
Denise, Kardashian's very serious subject. I need to mention one thing. I found out that her Beverly Hills baby doctor was the same doctor I had.
Oh, my.
What?
So you're practically related then.
1 degree of separation, okay? And I absolutely love her crazy husband, Kanye, and his crazy rant. Did you hear his rant? Anyway, just a little pop information there. He did this endless rant about why no one takes him seriously, and it was really interesting actually on I think Jimmy Kimmel. It was a recent thing that's been going around. It's worth listening to.
If you have to rant good. About why you're not being taken seriously, I think you're somehow having a further detrimental effect on the whole thing. But was it effective? Did you take it more seriously?
I thought it was pretty good, but this is a guy who's turned the verb, he has 2 verbs he invented that I love, Louis Vuittoning and Reeboking. He's like this guy. He is incredible with language. I think it's the most interesting language. If you want to talk one more last piece about books or what's a book or what's what and who's deciding, designing what. I love the language of rap, and I love the invention and the broadening of the language that they do. They do incredible things, and I have high regard for it. Although I love Dickens too, and Tolstoy.
And Kanye.
And
Dickens
Kanye.
Yes.
Absolutely.
They're all of a piece. Well, some of the Kardashians helped some authors, the Ducotes here, Kristen and Chapman Ducote. Chapman is a race car driver, and they wanted to, or they did, I don't know if they published, they wanted to do a Kickstarter funding, like you did, Hallie, for their book, Naked Paddock, about, and this is from Eric Gardner's write-up at Hollywood Esquire, life, love, and drama in the world of professional motorsports. They were supposed to appear on Keeping Up with the Kardashians spinoff, Kourtney and Khloe Take Miami. In case the first show wasn't shallow enough, they had to take it to South Beach just to make sure that you got everything that you needed from it. So they were supposed to be on that show. They, I guess, did a promo. They did go on the show and they launched their Kickstarter project, but 5 days after the project was up, Kickstarter pulled the project and then the Ducotes sued. And nobody's quite clear, the lawsuit settled. Nobody's quite clear why they settled, but the decision to suspend the project, Kickstarter said, was that they violated, again, the community guidelines in terms of use over the book. Not so much over its content this time, speculation goes. But Eric writes, the suspension might have had something to do with promotion. Spread the word, but don't spam is one of Kickstarter's tenets. You can't use link bombing forums, and you can't promote one project on another project's page. So, and there are tons of other rules that creators have to follow in being careful to promote their site or their project in a non-spammy way. So it seems like Eric thinks that these folks that do coats crossed the line and sort of is reading between the lines in the settlement documentation that's what went on there, and they yanked their complaint, and the parties are going to go their separate ways. But yet another pitfall for authors to beware of if they're going to go the Kickstarter route is that if you get a little aggressive in your marketing, you may find yourself not able to do that fun crowdfunding piece. Hallie, did you run up against any crises of conscience or ethics in the way you promoted Founders Lesson 3?
No, I love Kickstarter. I'm pretty partial to them, and I do think it's getting overwhelmed, right? They're getting so many requests, and I know some good projects that I've heard that were turned down. They just don't. I'm not even sure why some were, but I know they're turning down many more projects now than they were. So, all
right.
I have nothing but good to say about them. I like them a lot.
Evan, any thoughts on Kardashians and link bombing?
Well, that has to be really disappointing to the folks involved here, because it was such a big deal and they'd gotten such good publicity only to have it pulled away from them there. So, but I mean, there's a lot going on that we don't know about, because it sounds like the settlement, there were a lot of confidential terms, but that really would had to be disappointing. Sounds like Jonathan was getting ready to say something even more insightful.
I'm certainly not going to promise. I wonder about prohibiting spamming in terms without defining it.
Yeah.
Right.
If you get on a television show legitimately with a huge audience and you're able to get the word out, but you haven't sent a single email or promoted it in another Kickstarter campaign, I'm not sure how that might be defined as spamming. It just might be PR success.
Exactly.
It's a fine line.
If it gives Kickstarter the right to reject it just because on its own judgment, fine. But if it's basing that kind of a rejection on its terms of service, you have to really point to the particular activity that would violate it. I also, to Tally's point about Kickstarter maybe rejecting more, I wonder if that has anything to do with the new crowdfunding rules and the desire of many of these sites to become facilitators for crowdfunding, which means that they're being looked at more by financial regulators, the SEC and others, and they want to look more legitimate.
Mm-hmm. I just pulled up the what is not allowed on Kickstarter guidelines, and there's some interesting stuff there, like you cannot use Kickstarter to buy real estate. You cannot offer alcohol as a reward. So,
or the genetically modified organisms.
Yeah,
I thought that
like
one was
that
important.
One. No GMOs as a reward. So, Hallie, you were going to buy me a glass of wine, I think, because I kicked in on Kickstarter. I'm sorry, I'm not going to be able to let you do that.
That's right. Don't tell anybody I said that, or I'm in big trouble. It was fun. One of my favorite ones was the 8-ball, the magic 8-ball, which in my book, it's about venture capitalists and how they decide to fund this woman entrepreneur's fictional company or not. And she goes in and does her pitch, and the guy has an 8-ball and he shakes. He's like, sorry, no, we're not going to do it. And she's like ready to reach across the desk and strangle him. She's had a hard day. But and I made that 8-ball available as like one of the sponsorship levels. People love that thing. It was ridiculous. So sometimes you put these silly treats that people can get if they, support you at a certain level, and you can't even believe the ones people want. So,
right. So I was telling people before the show, I can't remember if I've mentioned it on the show, but I've had puppy brain for the last couple of weeks, which is like having mommy brain, only smaller and slightly more whiny, where, things just aren't clicking together. Your synapses aren't firing in the way that you would like them to, partially because of lack of sleep, partially because your entire world has been upended by something small and cute. And so I did want to mention before we leave stories on terms of service that I optimistically last week, when we were talking about Google's change in its terms of service regarding sharing of your endorsements, we had pulled up an image from Cash Hill's site that showed the box unchecked, which apparently was, the screenshot of what would happen after you went in and affirmatively unchecked the box. It doesn't come unchecked to begin with. You do have to go in and affirmatively opt yourself out of the shared endorsements. And I'm sad that I saw that picture and just assumed that, hey, somebody actually did this the right way and made it opt in instead of opt out. Too bad, Google. You had the chance to do it right. It doesn't look like you did. Hallie, did you opt yourself out of that?
Yeah, you bet. You bet.
Yeah.
Hey, but where's the picture of Caramel?
Oh, where is she?
You talk about the dog. I want to see the dog.
Oh, yeah. I'm going to have to leave it to Alex if he still has it handy to.
Is that why you had caramel latte last week?
No. Well, no. Yes.
Now I get it.
The caramel latte fascination predated the dog, actually.
Oh, look at her. Cute.
Yeah, she sure is. She's been dominating all of us with her little 3-pound self. So we're working on getting life back to normal. All right, we've been talking about things around contracts and authorship. Let's talk about some copyright-related considerations as well. Evan, you had an interesting write-up on internetcases.com about a case where the author was attempting to exercise the author's rights by speeding the process up. As Hallie was saying, self-publishing is a much more friction-free way of going about things than the traditional avenue. And it looks like the author in the case you wrote up got impatient and decided she was going to self-publish. And the publisher found that objectionable and sent DMCA takedown notices to Amazon, which Amazon complied with. The author was pretty confident that she had the rights to do what she did and filed a lawsuit and is attempting to do that very advanced, DMCA maneuver, which is recovering from the person who sent a takedown notice when they shouldn't have done so. Can you tell us a bit more about this?
Right. Well, first of all, this must have been a romance author. I don't know, because the facts say that she wrote a new book every 2 weeks. Who does that? My gosh. And that kind of played into the facts here, because she went in for a TRO, a temporary restraining order, against the publisher, saying, "Judge, tell the publisher that it's okay. Tell the publisher to tell Amazon it's okay to allow these books to be sold." And the holding of the case, which is really the secondarily important thing here, was that she hadn't shown that this delay because of the DMCA takedown notices that the publisher had sent wasn't causing her irreparable harm. What I think is the most interesting thing and the thing to really be learned from this is sort of the meta issue of whether whether the publisher should have or could have sent the DMCA notices in DMCA takedown notices in the first place, which is the ultimate issue in the case, since this is a 512F case. Because what we learned from the facts is that this was a contractual right that the publisher had of exclusivity, that the publisher would only, or that the author could only. But that the publisher had exclusive rights to any sequels, and a right of first refusal, I guess, is what it really was. That if it was a sequel to any work that the author had written before, the publisher could be the only one to do that. Well, the author felt that the works that she had published, self-published on Amazon in her haste, were not considered sequels, but the publisher sent the DMCA takedown notice nonetheless. So that is an important object lesson for any sender of a DMCA takedown notice, to ensure that the right that you are asserting as having been aggrieved is a copyright right and not some other form of right, like a contract or like this this contractual provision of exclusivity. I think in our quick reaction to things like these, if you're counseling the publisher, your position would be, well, hey, this is being published online without our authority. Let's send a DMCA takedown notice. It always warrants carefully thinking about and ensuring that it really is a copyright right that's at issue if you're going to seek that form of remedy. So it's that sort of meta issue, which is really what I think is important and useful from thinking about this case.
Yeah, it's a good reminder too that TROs are just hard to get, and you have to really be able to demonstrate that you're going to suffer. The term is irreparable harm, but the court has to really be convinced that you cannot be made whole unless they step in at that juncture.
Yes, and that's where, in this case, where the fact that she did publish books every 2 weeks would seem to go in her favor, because if she's used to churning them out that quickly, it's not like somebody who's writing a book every 1, 2, or 3 years. If her readers truly are expecting to have the new content come along with more frequency than even most periodical magazines, you would think that any delay would really be irreparable. And so that underscores, these are difficult to get. I don't know what actual evidence she submitted. The court didn't buy it in this case, but you would think that if there were a situation like this where there would be irreparable harm with the frequency of publishing, it would be this one.
Yep. All right. Well, let's move on. Jonathan, you've been paying attention, and you regularly pay attention to issues relating to privacy and surveillance. So let's check in with some of those with you if we can. I'm sure that the NSA is listening to all my calls. I'm sure that they're doing man-in-the-middle attacks in my search activity. Now they have my address book too.
Yep, that is a story from the New York Times that the NSA is getting access to contact lists from emails and messaging accounts. Your email, your address books are everywhere, and you have different ones in different services. Mm-hmm. And the question is, how those are stored, whether they are protected. And we have yet another leak from, more from Edward Snowden that, according to the article in the Times, which further refers to the Washington Post, the NSA collected 444,743 email address books from Yahoo, another 105,000 from Hotmail, almost 83,000 from Facebook, and so on, in a single day in 2012. You think about some of the content versus non-content distinctions within, for example, the Electronic Communications Privacy Act. Mm-hmm. The challenge of that analysis, even beginning to go down that road, is that assumes that any legal structure is relevant here. Mm-hmm. that we need to even think about under what traditional, typical, familiar law this might have been done legitimately. Mm-hmm. But it's a total blank page. Mm-hmm. You've got the FISA court, and the FISA court does what it does. And the NSA then does what it does, assuming it even went to the FISA court. And then these things get swept up. And is it relevant? Does it provide any evidence against the person whose email or whose contact list was taken? Or is it simply a nice way for the NSA to get access to otherwise non-public contact information that individuals have, but directories don't?
It seems so strange that companies get in such huge trouble for not managing personal and confidential data well. They get fined, they get sued, they have, ongoing compliance obligations to government agencies. It seems like all they really should need to do at this point is say, we were just making it easy for the NSA to access this data, and maybe they'll be given a pass.
Well, they're not allowed to say that, right? One of the
Right.
big controversies now is that the providers are fighting for the right to even say they've been asked, let alone what they did with it. The transparency reports you see from Google and from Twitter and other providers now those do not include NSA requests, which must be kept confidential. You're seeing pressure from overseas where there are different laws, and U.S. companies are being pressured from overseas, from the EU, to disclose those requests from the U.S. government. I don't envy the U.S. information services companies. They are in impossibly difficult situations. They are getting these requests that they're not legally permitted to disclose. They may be hacked, call it malicious or otherwise, by the NSA if there are vulnerabilities to get this information. You may have people within the companies who have access to these databases who have particular sympathies who are providing it out. I think their one remaining path is to manage expectations of customers and to at least let people know in much more effective ways than they do now the limits on the privacy of their content, their non-content, their contacts lists, etc.
Evan, any thoughts on contact lists being shared?
I got used to it with Path, so this is nothing new.
Yeah. Yes, exactly. Hallie, have you just kind of given up? You're going to just publish everything online and do a Robert Scoble? My life is an open book.
I don't know about that.
No.
I wanted to ask you guys quickly, if we may not want to go back to this, but about the Amazon Worlds program that was announced in May. Have you guys talked about that before?
No. Bring us up to
It's
speed.
sharing royalties, and I'm going to read from Amazon's site. It's sharing royalties for fan fiction. So it says news stories inspired by books, shows, movies, comics, music, and games. So
We did talk about that now that I think about
Yeah,
it.
we did.
That to me is, I think that's going to bring up so many more crazy, like, wait a minute, somebody just wrote something based on my thing and I didn't want them to. So they actually have made a way for you to share your revenue. If you're, Agatha Christie or some well-known author or whatever, and people write fan fiction about you, they can make money for their fan fiction and share in the licensing, and you get money too. You don't write anything. You just sit there having been the person who wrote a certain series that was popular.
Right.
So if I wrote something around Breaking Bad and used all their characters, if Breaking Bad's decided that that's okay, they want to participate in Kindle Worlds, that is possible. So I just think that publishing is it's becoming, I like to call it social publishing. If you happen to know too, 50 Shades of Grey started as fan fiction of that teen crazy book about vampires, Twilight, right?
Yes.
And that's how that all started. And so a lot of people are writing things all at the same time or working together on things. And who owns the rights to whatever? I mean, it's going to be really a mess. It's already a mess, I think.
And this is a shade different from YouTube's approach, similar approach to music and things appearing in videos, where YouTube on the one hand will go to the rights holders and go, okay, you have a couple of options here. Our content ID system has found that this video has work that may be yours. Do you want to participate in revenue from this video, or do you want it taken down? Amazon instead is actually going out and proactively getting licenses from big media entities like, here's their list: Warner Brothers, television groups, Alloy Entertainment for Gossip Girl, Pretty Little Liars, and The Vampire Diaries, Valiant Entertainment's Archer and Armstrong, Bloodshot, Harbinger, Shadow Man, and Exo Man of War, Hugh Howey's Silo Saga, Barry Eisler's John Rain novels, Blake Crouch's Wayward Pines series, and the Four World Saga by Neil Stevenson, Greg Bear, Mark Teppo, Eric Bear, blah, 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 going on. More licenses for more worlds are on the way. So right now it's a pretty limited universe of stuff that you can do this with. But you're right, Hallie, it's a fascinating way of going about it and making publishing more social.
Similar, even with Kickstarter, people would say, I want to be part of your book, and here's what I want you to do with the book. They would tell me who should be in it and what plot I should have. And can I fix this and can I do that? So it's a very strange world that's, what's going on out there. And who owns what rights to what? It's kind of amazing to me.
It really does bring in a bunch of metaphysical copyright issues because you get down. I mean, first of all, derivative works are tough, even if you hold yourself out as understanding copyright law. The whole idea of, who has what rights, and there's that famous case, Stewart versus Abend, that talks about, the new rights emerging and, what does it mean to incorporate or be based upon? So you've got all that. And then, once you get down to these elements, what you were just talking about right there, Hallie, is the kind of the idea expression dichotomy. At what point does the plot become protectable and those elements in it as well? And so there's all of those issues. And then Denise, you said something intriguing by saying that it's different than, you said a shade different. I thought that was quite apropos talking about 50 Shades. I know that wasn't inadvertent.
Influential, definitely.
Yes, of saying that it's like what YouTube is doing. But with literature, I mean, how on earth would you actually register what, how would you make it a technological process of registering what work is being built upon? Because with video, you've got the data there and you can see if it's the video content. But with literature, this is all, ideas, being expressed, and it becomes protectable once expressed. But it's so hard for us to ascertain algorithmically when, for example, a particular work, is Stephanie Meyer's creative expression being used to create this new work of literary work, this new literary work here. It's a much more difficult challenge. And I guess that's why perhaps it needs to have more control within the structure. Lots of really, really fascinating ways that different things in copyright play into this.
Yeah.
Of course, with fan fiction, and this is the category we're talking about, you can do a search for character names and place names. And that can allow a more definitive determination. It wouldn't necessarily pick up 50 Shades of Grey as it was published. And there's a very interesting question about idea expression and derivative works there. But traditional fanfic, it absolutely would. And then we're back to the question we started with particular content and the classic slash fan fiction, where different characters are matched up by fan fiction authors in romantic and sexual ways that were not necessarily part of the original work. But if you put the characters in that, would the Exo Man of War person want his characters to do certain things? And
exactly
how does that get, who does the editing? Is it Amazon or is it the original media holder?
Really, do you want to know what Robin and Batman were doing in the Batcave? Really? Do you?
Oh, jeez.
I don't.
There are so many classic panels from 40s era Batman stories where jargon was somewhat different. There's an entire Joker story about pulling a boner. You can look this up. But that is, we can talk comics another time. I think I'm happy to come back for that podcast.
We'll definitely have to do that one. Well, in the meantime, we've got lawyers with confidential data on laptops again. It seems like our profession is one of the last to get the memo that you don't actually store sensitive data on laptops, because lo and behold, those things get stolen. And then you're among those ranks of people who, are getting sued and fined and have ongoing regulatory obligations because you dropped the ball on the privacy front. Jonathan, why don't you bring us up to speed on the Legal Aid Society of San Mateo?
That is a particularly interesting case where lawyers lost confidential information because in the notice, Legal Aid of San Mateo, as you say, announced that it had had some laptops stolen. On the laptops, they had client information, and they were required under California law, at the very least California law, to send out a data breach notification letter. What makes that case more than the typical data breach, or even more than the typical lawyer data breach, is that among the types of information that the Legal Aid Society of San Mateo County announced had been taken was health information. That because they do certain kinds of healthcare advocacy, apparently, their laptops included health-related information of their clients. So not only are lawyers now having to deal with our ethical obligations of confidentiality and the data breach issues that other businesses have to deal with, but lawyers with healthcare information from their clients, and whether it's legal aid or whether it's a lawyer doing med mal or representing hospitals, they've got to consider whether they are subject to health information privacy compliance, if not as a covered entity under HIPAA, as a business associate with those requirements. So yes, it's very embarrassing. I think that lawyers sometimes, because we're so used to keeping everything confidential, we don't take the additional steps that a traditional business would with private information. We just don't think about it in the same ways. But we are subject to it. And, those lawyers are not only going to have to deal with data breach exposure and potentially health information exposure. We'll see if HHS brings an action. But those lawyers might also face ethics violations and ethics enforcement in the jurisdictions in which they're licensed because they breached confidentiality.
Oh, boy. All right. Well, this would be a good time to make HIPAA compliance our second MCLE passphrase for this episode of This Week in Law. Do you want to tell us about the EU and what's going on there on the privacy front? We know they don't like Amazon much. They also don't like people who expose your private data. What are they going to do about it, Jonathan?
Oh, there are a few things happening on the EU front. There is some really strong discussion that the EU Data Protection Directive, and particularly the safe harbor that has existed over the past few years, allowing non-EU companies in the US, for example, to self-certify and be permitted to transfer public personal information into and out from the EU, that safe harbor is being revisited because it's simply not working. And then came across a very interesting statement from the Council of Bars and Law Societies of Europe that apparently is concerned about government surveillance that not only includes consumers, but actually is going into confidential information held by attorneys. So it's the flip side. It's not the carelessness of attorneys necessarily, but back to what we're seeing with the NSA, that you have government agencies that in their surveillance activities are not only surveilling the suspects, but potentially going into lawyers' files to get access to that information. And the concern that these European lawyers in this circumstance are expressing about their exposure and how that violates the trust and the obligations that lawyers are having with their clients.
Yeah, that's definitely a huge issue. Evan, are you seeing any shifts, anecdotally in the profession on this front?
Well, I mean, apart from the precautions that we take already, I don't see anything in particular. But what I do see as really important here, with having the NSA stuff come to light, this sounds a lot like what we talked about when Mary Grant was on the show. She raised the issue of what is a company's. How should a company think of its responsibilities to its users who have made certain privacy promises to those users when it comes to government surveillance on all of this? So it's there's different threats to the. I'm trying to figure out what I'm really trying to articulate here. There's always been the concern about inadvertent disclosure or some other way of client communications, privileged client communications coming out there. This just adds a whole new dimension to that, a vector for this information to get out that we're not used to thinking about. So it continues to be a moving target.
Jonathan, do you think that with more and more government surveillance coming to light, lawyers are going to, be counseling clients that we're going to keep your information as confidential as we can, but there are certain things over which we have no control?
I suspect the lawyers that are dealing with particularly sensitive information are already doing that. I wonder whether this will filter down to lawyers who aren't as aware, who are using services like cloud storage without necessarily investigating the reliability of the cloud storage system's promises, or the lawyers who are considering outsourcing some of their services.
Right.
But,
well, we're back to the Legal Aid Society, right? If they'd been on a cloud service for their storage, their laptops wouldn't have been stolen and they wouldn't be facing the problems that they are.
Unless the cloud storage service in particular was maliciously hacked into out of their control.
Right.
Or the laptops could have had encrypted files and then it wouldn't have mattered.
Right.
So anytime any professional lets data out of his or her control, these possibilities exist. Our obligations are, from an ethics perspective, limited by reasonability. We don't have an absolute obligation. We have a reasonable obligation that's not going to comfort clients very much.
Yeah. All right. Well, for clients who need more comfort or education, or individuals who do, we have a great resource of the week for you that Jonathan came across. It's from the Office of the Assistant Secretary for Planning and Evaluation. That's part of the Health and Human Services Department of the United States government. They have a privacy committee, and they have a whole mess of privacy-related links, including things on the Privacy Act of 1974, various information on U.S. states, government data protection officials, on down the line. It's a really huge list of various flavors of data and what sort of privacy may apply. Anything more you want to add to this, Jonathan?
I think there are a number of government agencies, particularly now that the shutdown is over and the sites are up, that have really good collections of information for different populations. You can look to the Office of Civil Rights of HHS for the HIPAA stuff. FTC does a really good job of educating both consumers and businesses on the basics. But what I liked about this list is, first of all, it's not where you would typically find it, but it also links to a lot of the primary sources in a lot of different topics well outside of health and human services. And also the international stuff that even local businesses must consider, with which they need to be concerned, because what they do here might violate laws in other countries. And then you have executives who decide to take a trip and get arrested for privacy violations, not realizing that what they did online mattered. So I really liked this, and I hope it's going to continue to be updated. It has become one of my regular bookmarks, and I'm glad that you're able to share it with your audience.
Yeah, us too. And folks, it's got a pretty short length, but I'm not going to just read it out here on the show. You can go get this link and everything else we've discussed on today's show over at Delicious, where we put the links to each episode. Delicious.com/thisweekinlaw/232 will have all this week's links. And for our tip of the week, what we're going to do something different since we have Hallie on, and she's not a lawyer, is an author. She had some good author-related legal questions that she wondered if we could just kind of spitball around. So I thought that we would do that, and they could be tips for anyone out there who is a creator and might have similar concerns. Hallie, your first question was what legal considerations exist around referencing real people in fictional works, right. Such as, for example, something we talked about a lot on the show when it came out, the Facebook movie comes to mind, where it's a fictional account of what happened, but definitely real people are involved in the story. Do you need to be careful doing that? Yeah, you do a lot. Defamation being one thing that can come and bite you if you're portraying somebody in a way that is suggesting that this really happened, but it didn't. What else? Right of publicity issues where you're using someone's name and likeness without their permission. But there's got to be some leeway for referencing real people in fictional works, right, Jonathan?
Yeah, I think that often the authors consider questions of not only the right of publicity. If you're using someone's fame to help market your own book, that's when you have some problems, and there's some really interesting cases. But if you're simply referring to facts, newsworthy situations, or you're fictionalizing people from the distant past, I don't think you have to worry about it. Authors who are using current individuals in their stories by name, as opposed to simply fictionalized versions, need to make sure that it is clear to all concerned that this is fiction, that they are not simply trying to make accusations, state facts that aren't true. Having, the disclaimer at the beginning of the work may not be sufficient. But
so yeah, this is definitely a situation where you're going to need a lawyer to vet the use in your work. Evan, any further thoughts?
Well, it perhaps is less important now since we've gotten a bit of guidance from the Ninth Circuit on this. But if you'll remember, the football player Jim Brown filed a Lanham Act action against.
That was the video game case.
Yes. So there's been several important video game cases where athletes are being, or the likenesses of athletes are being portrayed in these video games. And Jim Brown was unsuccessful in asserting that Lanham Act claim, but that doesn't mean that the law is settled in that area. Right. So it's one of those points on the checklist you would want to think about in considering these issues. I mean, it's incredibly complex, and there's law from different parts of the country that appear to say different things on the right of publicity, the Lanham Act, defamation. But specifically with the right of publicity, there's was it the Third Circuit? I think that says some stuff about it, and then we have the recent decisions from the Ninth Circuit. So it's tough.
I'm actually in the midst of trying to put together some research and writing on how the definition of fame has changed, and whether instant fame in the internet era could impact not only the right of publicity, but things like trademark dilution. So maybe I've just preempted myself. Nobody else read about that. I'm working on it.
Don't talk about it.
Going through those cases as well, so much of the analysis, particularly in the state right of publicity cases, is financial. How much can someone capitalize from his or her name, his or her image? Well, ask Rebecca Black. Right? Ask these people who are instant superstars. They make what to us would be a lot of money very quickly, then fade away. Is that going to be enough to give them rights of publicity or not? And how are there have been some really interesting cases about things like the Nyan cat in Scribblenauts, the video game, and thinking about famous brands, famous marks in dilution. Well, what constitutes a famous mark now, and is something that becomes part of a viral video, like, well, Grumpy Cat, my favorite. No offense to the dogs. I love the dogs, but I loved Grumpy Cat. Grumpy Cat's owners, if you look up Grumpy Cat, you have to find him. And they are very seriously commercializing Grumpy Cat. I think there's a Grumpy Cappuccino now. They are doing this in a legitimate business way.
Hopefully it has caramel in it.
You'll have to ask the Grumpy Cat about that. But, that's something where it was a meme. There he is. It's a meme that has become a business. And it will be very interesting. And I'm sort of thinking through the issues of what should the law do with the new definition of fame?
I think
that's a fascinating topic.
An important concept, and that is what we call micro celebrity. I would think as well. We can sit here and think of all kinds of people that we know well because of the community that we're involved with, and as you expand that out, you get to actual real celebrity, somebody like that everybody knows, a famous actor or something like that, as compared to somebody who might fit the definition of micro celebrity, like. Right. We were talking about Guy Kawasaki, probably a good example there. I mean, he's very, very well known, but seriously, 9 out of 10 people on the street wouldn't know who Guy Kawasaki.
My husband wouldn't know who he is.
Yeah. Right. But of course, he's famous in our world, so there's that. Right. Where does that fit in? And how is a court actually supposed to handle that issue?
Right. Hey, Denise, can I read you something I wrote and you could help me?
Sure.
Because I think it's bad. I think there's a problem. It's two women in a restaurant in Cambridge, and the one says to the other as she's looking at the menu, what's this fascination with kale? She asked me, looking over my way. It must be some Mark Bittman thing or something. So can I mention him? And what happens if I, as you can do in self-publishing, if it seems not good, I change it and I republish and it's not in there.
Right. Can you make a Mark Bittman joke? Without, we are not your lawyer and this is not legal advice.
I know.
It seems to me like there should be room for a Mark Bittman joke. You're not using him as a character. You're not saying anything that he did or performed any kind of act that he would be afraid to be associated with.
Right. But once that book gets on your backlist, will it be relevant to your audience? Will it make sense to your audience in 2 or 5 years? That's the creative question. Do you want to be so timely, right? Do you want to be so timely that you are dated?
I do, actually. I think that's a big part of self-publishing now, too, is how fast and fresh and right now it is. And that's okay. For me, in this case, I wanted him in there.
Right. I have a great referral for you if you have not already found a lawyer to help you out with good legal questions. He's been on our show, and he's been in the blogosphere for a long time, and his name is C.E. Pettit. And he's a lawyer for authors. His Author's Lawyer is the name of his blog. And whenever I run into authors with questions, I send them his way. And if he can't, if he's not the person, then he will know who is. So he's very good with specific questions like that. Hallie's other question related to something you mentioned a second ago, Jonathan, referencing brands in fiction. So if it hadn't been Mark Bittman, what if she'd said it must be some kind of Food Network thing or, some sort of well-known brand or enterprise? What do you think about that?
You're probably better off with a brand because brands protection comes under trademark. And it's all about using it to sell something else. And the implied endorsement stuff. So if you put it in your title and it seems like it's an official book, that's one thing. But you put a brand in your story, as long as you're not somehow diluting the quality of the brand by defaming it in some way. I don't think there's any issue that I'm aware of in the law. I certainly haven't seen the cases. You see some reference again in the video game sphere about having brands on the signs in the background.
Right.
And that has not been a real issue because it's just seen as scenery, and they're not part of the promotion of the product. That trademark in some sense is simpler that way. If you're talking to consumers and trying to sell something based on this reputation, then you perhaps have an issue. If you're simply referring to a brand in the context of a copyrighted work, probably don't. But check with your lawyer.
Right. Hallie's last two questions were both copyright related. One is quoting lyrics in another creative work, and one is for books in particular, cover art, managing copyright concerns about cover art. On the second front, I would certainly recommend making sure that you have all the rights that you need in the cover art, whether you're using something that's Creative Commons licensed, or there's some other licensing that you have or have not paid for, but you have the license and permission to use the work, and you have that in writing. I wouldn't, the thing not to do is just to go around finding good images, on the web or elsewhere and deciding that would look great as my cover art.
Let's also remember when you're talking about particularly cover art, that it's not just about the copyright. If there are, back to this rights of publicity, if there are people whom you can identify on the cover, you might need their permission, even if you have the permission of the photographer. The classic example I've run into in practice over the years, my favorite one was the famous picture of Buzz Aldrin on the moon. He's wearing the space helmet. You cannot see his face. It's the classic reflecting, Earth and background image. It could only have been two people in that picture. It was either Neil Armstrong or Buzz Aldrin. It was Buzz Aldrin. NASA, they're both NASA employees. There's no copyright in that image, but Aldrin has in the past, perhaps he still is, he has exercised a right of publicity in his image for commercial use. So putting that image on the cover, you don't have to worry about copyright if it was taken by a U.S. government, but if there's someone like Aldrin who's recognizable, you do have to get that permission or make sure that whomever from wherever you got the rights to the image, they got the releases, not just the license.
Right, and then the lyrics question would be the same kind of answer for any kind of snippet of a copyrighted work that was included in another creative work. You either want to clear the rights affirmatively to what you're using, make sure you have specific affirmative permission to use what you're using, or you want to have a good, strong opinion that your use is fair use. And that's a slippery and moving target because there's really no way to know if something's fair use until a court looks at it and decides, that's fair use. So that's sort of the boat that you're in with that kind of consideration. And again, just like with movies, people, when they incorporate other things, they have to go through and do a whole copyright clearance rigmarole before they put the work out. I would think that you've got to do that with books as well. Evan, any thoughts?
Well, no, just to underscore the complexity of fair use. Seems like we brought up all these complex issues today, right? Nothing's going to lend itself to clear line, to bright lines with all this. But, with the lyrics, I think that's a really interesting example of how to extrapolate from which to extrapolate a discussion on fair use, because one of the most important fair use factors is the transformative nature, using the work for something, a different object than it was originally intended. So if you're writing a book and you have some song lyrics in there, I could see how you could have a really good argument that that's a transformative use, because say, for example, it's the story is set in the 1960s and you have, Neil Sedaka. I was saying, Neil Sedaka, but I'm wondering what that says about my own psyche. Why that's the first thing that came up. I was trying to think of something in the old days. So, that to set the scene, that's certainly different. You're not going to go buy the 45 of O'Carroll because you didn't, because you saw it there. So good stuff.
And in a wonderful multiple segue, talking about films, talking about public fair use, and even talking about comics, I'd like to recommend that people look for the comic book that was created by the Center for the Study of the Public Domain at Duke Law some years ago. It's called Bound by Law, and it's a phenomenally fun but also informative work about fair use by a filmmaker in the context of the story. But it is free of charge to access. It is available under a Creative Commons license, and we'll put the link in the show notes, I'm sure. But it's definitely worth reading, and even if it doesn't answer all the questions, it certainly raises them nicely.
Yes, it's a part of it is just knowing what questions to ask, and then finding the right person to ask them to before you go forth. So thanks for all those great topics, Hallie. They all, I don't know if we gave you any good tips here or not, if we just made things more confusing.
No, it was very helpful. And it's amazing to me as a writer how many things I had to think about in terms of this. I didn't expect that,
Right.
Thanks.
You're welcome. Thank you. And thank you so much for coming on the show today. It's always so much fun to talk with you. I haven't had the chance to talk with you for this length of time in a very long time. So that's been a huge treat. And I'm so proud of you for getting the book done and getting it out there and getting it launched. And I am a good way through it, but not done. And I'm enjoying it thoroughly.
Thank you. I'm glad to. It's funny to talk to real people that really read your book. You feel a little like, oh, that's strange. I was talking to a friend the other day, and they're like, well, how's so-and-so, a friend of ours? How's the other person doing? Yeah, they're great. So why did Monica do that? They say. And I'm like, wait, are we talking about real people or fictional people? Oh, fiction, he says. Like, that should all be, it's all one world. I'm like, it is in my head, but it shouldn't be in anybody else's. So it was very strange, but.
Have you had any book clubs that you know of discuss your book yet?
I'm actually just about to go do a book club thing in about a week, and it'll be interesting.
Yeah, that's fantastic. And, also a published author here, not to, slight anybody else who's got their book out there. Jonathan has a free ebook called Shooting from the Hip, Managing the Risks of Portable Computing and Smartphones in Your Business. So the Santa Clara Legal Aid Society should have gotten the memo and read your book, clearly.
That's right. I want that.
Yeah. That's at mobilerisk.com. I've gone through the publishing in all sorts of different ways. That was just a free ebook. I did a business book in '99 with Bloomberg Press. And then most recently, I have a privacy case book, or course book, I should say, that came out from LexisNexis last year. And so I've had the agent. I've done it myself. I've worked with academic publishers, which is an entirely different world. Yeah. So I don't have people asking me why characters did things. There are people who are getting graded based on the stuff that I've written, which is a little bit odd. But it's definitely fun, and I've talked to lots of friends who've published in different ways about publishing in other ways. A friend who's self-published in print, who I'm trying to get to bring her book back as an ebook because it's still very relevant. So I've learned a lot, and I really appreciate it.
That's great. It's been so fun chatting with you today. And Evan, always great to round up the week chatting with you and getting to know what's been going on in your world for the last 7 days.
Yeah, I enjoy it as well, and this has been really a fun conversation for me. I really have enjoyed hearing, Hallie, your perspective on these things as an author helps help me get a better sense of what's going on in this space. So I've really enjoyed that. And Jonathan, very nice to talk with you. I feel like I've known you for years on Twitter. You're one of those, it's like, oh yeah, I know that guy, but now I know what you're actually like. So it's been great.
Yeah, Prof. Jonathan on Twitter. for anyone who is not watching the video and doesn't have the benefit of having seen that under Jonathan's shot the entire show. Also, Hallie is just Hallie on Twitter. One of those, share prints kind of phenomenon. She's just Hallie over there. And I'm Dee Howell, and Evan is Internet Cases. So Twitter is a great way to hit us up between the shows. Let us know what you liked, what you didn't like, what you'd like to have discussed, what you'd like to delve further into. Suggestions for guests are always welcome. So whatever you want to shout at us, please do so either there or over on Facebook or Google+. We have pages there too. And we're thrilled if you've watched live with us here. We recorded, as we do every Friday at 11 o'clock in the morning. That's 1800 UTC at this time of year, when you can catch us live at twit.tv. But if you can't watch live with us, don't worry. The show is on demand, available for you whenever your schedule permits. If you go to twit.tv/twill, you'll find us there. youtube.com/thisweekinlaw. We're on Roku. We're in iTunes. However you like to consume this sort of entertainment and education will be there for you. So we really appreciate your joining us. Shoot us email too if you have something a little more confidential that you don't want to share with the world. Evan is evan@twit.tv. I am Denise at twit.tv. We love hearing from you in any way, shape, or form. And we have loved that you've joined us today and really had enjoyed this look into the world of modern publishing and the great stories that you brought us, Jonathan, on the privacy front too. So thanks, everyone, and we'll see you next week.